past it, but I'm just thinking.
I saw that. She said, yeah, I saw that on the sheet, and then she sent me a text, which is great.
Yeah, good news, boys.
Well, we are on section 15, which is our last section. We have a few rules to talk about and just a couple cases. First, I want to talk about, though, the final examination so that we have some awareness of what it looks like. For all of those of you who took the midterm examination, you have an understanding. But it's going to be, if you look at some of my older Civ Pros, if you look at the remedies from other years, you're going to have an essay question that gets into a lot of the areas that we went through over the course of the semester. And you'll also have 10 shorter answer questions, which will be, you'll be required to define completely various concepts and then apply them to the fact pattern if they apply at all. But I expect you to know the law cold. I expect you to be able to express it clearly, and I expect you to be able to apply it as well. And that's what you're looking at. And I would suggest to everyone that you look at some of the old exams. Topics change over time. The substance of the technology or things like that can change, but a lot of what we do in the law, and especially in the courts that it starts as being known as equitable remedies, which goes back centuries and centuries, really deals with a lot of law that's developed over time but is pretty stable. And so you want to have a good command of the law and then be able to clearly express it and apply it well. And that's what I'm looking for on the final exam. And you should look at some of my old exams so that it's not going to come as a surprise to you what the essay will look like and what likely the concepts will be able to, you should have mastered by the time you sit down to take that final exam. You guys have any questions on that? Both in-class students and online students, everyone takes the same final exam. Everyone's measured to the same standard. And I've always said to people, it would seem to me that you should be able to sit down and come up with a list of, say, 25 or 30 concepts from what we've studied here, and the likelihood of those concepts being, most of those concepts being on the exam are pretty good. So if you've been paying attention, I don't try to hide the ball. I think a lot of it will be right there. But I'd especially look at some of the earlier exams so you have an understanding both at format and likely what the major areas that will be tested are. Okay? No one has any questions? We're all good? Okay. I mean, I don't try to surprise you. That's not my game, as you know. So look at them, and I hope everyone take that advice, because it's a shame if you don't have a head start on what you're likely looking at. So let's take a look at these 3 rules that we have, because they're not rules that everyone has been exposed to in law school, but they're very important rules from the standpoint of practice. And the first rule is Rule 66, and that deals with receivers. And a lot of these rules, we can use receivers. We saw them in the Republic of the Philippines case, but a lot of times receivers are also used as a post-judgment remedy as well. And in this group of cases tonight, between attachments and post-judgment remedies, what we're talking about is how are we going to either protect the potential source of revenue while the case is proceeding, or now we have a judgment, and how are we going to make sure we can satisfy the potential judgment? And it really is something you need to think about at the outset of the case, because you don't want to spend a year or 2 years of your life working to try and obtain a judgment and be successful at the piece of litigation, and then realize it was all for naught because there's no assets available to satisfy and pay that judgment that you've just obtained. So this is something you need to think about early on. Is this case worth your time, your client's time and money? And if so, how are you going to make sure that those assets then are available at the end of the process? But the first rule is Rule 69, which talks about the appointment of a receiver. 66. We looked at the rule before when we looked at the Republic of Philippines cases. What the rule on receiver allows the court to do is appoint someone to, in essence, act on behalf of the defendant in every way. And what that means is that instead of the corporation and its board of directors and its officers being in control of the corporation, the receiver, who is appointed by the court, now has the full authority to operate that corporation. When we talk about it in the context of a post-judgment remedy, what we mean potentially is to have the receiver appointed by the Superior Court to take over the corporation and even potentially liquidate it in order to satisfy that potential judgment. The receiver has all the powers to do with that corporation whatever is necessary in order to carry out the court's orders. And so this is a way, if corporations fail to pay judgments after demand has been made upon them, then the next step generally is, unless there is real assets, real property that we can seize and sell on execution, is that we have a receiver appointed on behalf of the corporation by the court and ask that receiver to liquidate whatever or all assets in order to satisfy that potential judgment. When you read the Republic of the Philippines case, it said that it's an extraordinary remedy, which it is, but in essence, you've left with no other choice at that point because they have failed to satisfy that judgment. So this is one method of seeking payment for an outstanding judgment. Rule 68 is with respect to offers of judgment, and it's a slightly different twist on this whole process, but it's again a very important rule for you to understand how it works. What Rule 68 allows a defendant to do is make an offer of judgment to, in essence, concede some portion of liability for damages here. And if the defendant makes an offer of judgment and the plaintiff rejects that offer of judgment and the case proceeds to trial, then if the plaintiff recovers less than the offer of judgment, then the plaintiff owes the defendant the costs that were incurred from that point forward.
That's only cost, that's not a fee, attorney fee, right?
It's costs, meaning deposition costs, witness costs, and the like. It generally does not include attorney's fees. There are some cases that the argument being when the attorney's fees would be awarded under the statute, that potentially you could argue that it also it involves attorney's fees. But as a general matter, it does not. If it did, it would even change that dynamic further.
I've always understood it the way you described it and thought it's not a very powerful tool. But if you were, let's say you were Goliath fighting David, and you had the ability to make this offer of judgment early, and potentially shift all of your expenses onto
all of the expenses, including attorney's fees, is what you mean.
Then you really would have some sway, right? I mean,
yeah, it would change the dynamic absolutely completely, because you're talking hundreds and hundreds of dollars an hour, which is just a debt that most small individuals, David, certainly couldn't afford in the long run. But even still, what we're talking about, depending on the type of case, is that even deposition costs can run into the tens of thousands of dollars, to say $10,000 or more in even a relatively simple case. If we need to bring expert witnesses in, that's an additional cost that could be chargeable under this. You're not talking the hundreds of thousands of dollars potentially in legal fees, but you could be talking $10,000, $20,000, $30,000 in costs that would be taxable. And for most individuals or small companies, that's not an insignificant amount. What it does is it changes the dynamic of the plaintiff who has zero to lose by moving forward all the way to trial, and asks them to at least think about, if you lose here, you are going to be on the hook for some item of cost, and it changes the dynamic somewhat. It would change it even more if, in fact, you could argue that attorney's fees should be part of that. But what happens is is that it has to be made at least 14 days prior to trial. The sooner you make it, if you're the defendant, the better off you are, simply because more costs are then incurred from that point forward. So that's the first thing, is that you do see it sometimes quite late in the process. And to me, when they make it that late, the decision's even easier to simply reject because I've got less to lose. If you make it early on in the process, then A, it gives us an opportunity to have a real discussion about what the value of the case may or may not be, and some understanding, both even from the plaintiff and his lawyer's standpoint of what the risks and ultimate returns are, and maybe it gives you a serious springboard for a discussion of what would be appropriate or terms to resolve it, and maybe allow us to talk to the defendant more. If you make it too late, it's only the costs incurred from the time the offer was rejected, and so it doesn't make sense to do it too late. But I don't see it used enough, frankly, by defendants, and I think it's a tool that those of you that will be representing defendants should think about more often, because it provides a significant opportunity to make the plaintiff reassess how far they're willing to go forward. Because for the most part, when we represent plaintiffs, there's nothing to lose with going forward to trial if they're not offering. And most times, the reason we as plaintiffs' lawyers end up having to try cases is they're just not being realistic as to what the value of the case is and what the loss is. So we have nothing to lose with impaneling a jury. Even if the jury comes back zero, they weren't offering us enough to make it worth not taking that risk. This changes that analysis a little bit.
Requests for admissions can have kind of a similar effect, right? If you do those early and they're like, won't admit, then they're on the hook for all the discovery that it took to.
Yeah, requests for admissions under Rule 36, the only ramification to just simply denying all the requests for the admissions that are made are, again, a cost-shifting feature of it, that if the other side is then put to the expense of paying expert witnesses to prove certain items that you should have reasonably admitted, that the court determines that trial should have reasonably been admitted, then the defendant can be taxed, or the other side, because it can be plaintiff or defendant, the other side can be taxed those costs as well. And it's important for you to understand it when you're using these tools or when you've received these tools, but it's also important specifically to understand, well, how can I change the dynamic a little bit here between the sides? And if you guys are going to litigate, if you're going to try cases, then it's fundamentally important to know the rules better than the other side, to know what the ramifications are to denying the request for admissions, or to using an offer of judgment in a smart way. Because frankly, even if there's only $10,000 in costs that are incurred after the offer of judgment, no one wants to pay a dime if they don't have to. If the offer of judgment is reasonable. And the problem with that is this. You try a case, you don't necessarily know, you don't know what that jury's going to come back with. You have an idea they should come back for you, they have an idea that they should be bringing a number north of X. But frankly, you try cases and you talk to them after the fact, and you find out the oddest things sometimes resonated with them, and the oddest things set them off. We didn't like their ties. And I know that is really trivial, but you've heard even things as stupid and inane as that. But usually, for the most part, it's on the merits and everything else. But a lot of times, you try a case sometimes, and the smallest point stuck home with them, and you say, well, what the heck? There's so many other more important points, but the smallest thing sometimes will affect them. And so, if you try a case, you can say, we think we'll win, we think we'll get X, but especially when you're trying them for money, yeah, realistically, it should be a big or small case, but $50,000, you know, absolutely out of the picture that the jury could come back with a number south of that? Not necessarily, depending on the case. And you can pick any number. And that's why the offer of judgment can become an effective tool, because your client wants an assessment from you. Well, what are the chances that we should do better or worse than that? And a lot of times it's really a crapshoot. And that's, you know, you try to give your best legal advice, and I think we should do better than that. But you also got to be realistic that even if the case goes exactly as you see it, the judge's rulings are as expected, and they're not always, that we get the right 12 people in the box that are going to see it the way they should. You know, it could take a vote among you today. Does he get the death penalty, or does he get the next 60, 70 plus years in prison without the benefit of release? And anyone who tells me, I mean, I don't know, can you guys predict that? Do you have an answer? What would your vote be, by the way, today? What do you think? What do you think they're going to come back? What would you do? Even what would you do?
Life.
Most of you see life?
Yeah.
No death penalty?
Why do you say life? I mean, why would somebody say?
Oh, you going death too?
I probably am, yeah.
This is what I think, and you guys can tell me because I'm saying this. I don't think there's going to be any mercy in this courtroom, period. I think they've heard too much suffering and too much pain. I don't think if his life is spared, it's because of mercy. I think it's because people think the next 60 years of their life in a supermax facility in isolation in a 9x12 cell will just drive you slowly insane, and that's maybe a worse punishment than a relatively quick death. No, that's
Is why people in Massachusetts typically go that way? Because I've never fully.
No, I don't. I think typically we don't. I think typically, if I could speak for all the people in Massachusetts, I think we don't favor a capital punishment. I mean, it's pretty severe. But if this, as we've said, if this isn't the case that justifies it, what does? But well, you laughed when I said it's the more severe punishment. To me, it really would be the more severe punishment to completely lose control and to be stuck under someone else's direction for the next. And we really are talking likely at least 60 years of your life. He's 20 years old. No, you don't. That doesn't. No one else agrees with that. You wouldn't rather be dead now?
I would rather be dead. But I'm not going to give him that.
I would be waving off that attorney being like, shh.
Well, but see, and that's the other part of that. He could choose that. If that really was his preference, he could simply say, don't defend it, right? Timothy McVeigh said waive the appeals, and he was put to death much faster. It would seem to be, based on the defense, that he's chosen to want to spend his life in prison as opposed to death.
Better,
so this group is pretty significantly against providing death penalty in this case.
But you know I'm from Alabama. What's that?
You guys put him to death pretty quickly, right?
Yeah.
Jaywalking still a capital punishment in Alabama?
It don't matter. You don't mess around in Georgia. You know what I'm saying? That's all.
So it'll be interesting. But at any rate, so okay. So if we went with this, we'd say, and which I think you're probably right. I think they're likely, the way the system works, all they do is get a single holdout, and that will mean that there will be no death penalty. If one juror, it works slightly differently than most trials work, is that if they are not unanimous, it reverts to the fallback position, and he gets life without the benefit of parole. So one juror gets a veto power over what happens here, and out of the 12, I think you're probably likely to find at least one, and especially if we look at the sampling, most of you would go with the other at any rate. You don't think it's more onerous to
I do agree. Yeah, I think it's worse to be 60.
Because are you showing him mercy because of his young age, his lack of criminal record?
Penalty. I think it's not about which one's worse, it's what's appropriate.
His senior brother just may have had a major role to play. I mean, he just followed the instructions, so technically he may not have contributed significantly to that, and that sparing his life may.
So you're buying the older brother influence, huh?
I want him on my.
See, I had two older brothers. I wouldn't buy that for a minute. I knew when they were selling me crap. You know, that didn't work for me. But I hear you, and you know, to me, the dysfunctional family situation is probably.
And especially in their religion, you know, in Muslim. I mean, I've been to Muslim school before. tend to be more listening to their elder brothers. So
Oh, is that true?
Yes, unlike the other religion, the Muslim elder brothers have much influence on the junior ones. That is why I think it may have been pushed into the act by.
Now, why haven't I heard that evidence yet then? No, I'm serious. I've heard a lot about, oh, he was a good kid in 3rd grade. As one of the court officers said to me yesterday, who the hell wasn't a good kid in 3rd grade? Right? I mean, you ever see, oh no, he was Satan. You ever have a 3rd or 2nd grade teacher say, no, he was Satan even then? No, so we've heard all this, because that to me, that would have some power over
Yes,
me.
honestly, I've been disappointed with the defense team so far. I mean, I was not impressed with their opening statement. I thought they didn't portray the guy where they were pushing us, he did it. I mean, just giving the most severe punishment. And maybe let's wait for the closing argument to see whether they bring those things up.
Yeah, but it's time. I worry. I think the jury's starting to turn off already. You have a long trial, and they've been there nearly 3 months now. We've been waiting for the defense. We're still waiting for it, in my opinion. Get to it, because they're making their mind. Okay, they're not supposed to make their minds up before they've got the final charge. They've been making their minds up, and they're going to come to a resolution. And you better give them the meat of your case soon, because they've had months and months of all this pain and suffering, and I think it's had a very powerful influence over them. I still think it's going to be very difficult for the government to get the conviction, but the death penalty. But okay, a little off target, but I appreciate the advice. So that's an offer of judgment. Let's just go to Rule 69, which is the rule on executions, because there's a couple of things here that you're probably not aware of as well that are important from the standpoint of thinking about practicing and the like. The court issues an execution on a money judgment, and that the execution is for the amount that is owed, and it's not just the amount initially sought, but it would include the interest that would have occurred during the proceedings as well. You are entitled to, if you look at Rule 69A2, obtain discovery in aid of the judgment. And they may obtain discovery from any person, but it says, including the judgment debtor, as provided in these rules or by the procedure of the state where the court is located. And then it goes on to talk about a few other things, but I want to talk about this. When you're initially doing discovery in a civil suit, you can't really inquire about whether they have bank accounts or real estate or assets somewhere to satisfy the judgment, because you don't have a judgment yet, and it's not relevant. It's not relevant or will lead to relevant evidence with respect to liability or the actual damages, unless arguably you have a punitive damage claim, and then what assets they have might bear some relationship to what the appropriate value of punitive damages would be. But so in some cases, you don't have that information prior to obtaining the judgment, in most cases. And we now have an execution, so how do we get discovery? Because in essence, the case is closed when you've got the execution. Rule 69 is the one that allows us then to, in essence, go now do depositions of witnesses, send out interrogatories, the typical discovery we would normally do. And this would be specifically focused on what assets the defendant may have and where they may be, so that we can try to satisfy the judgment. And so Rule 69 becomes important in the process when you've got a judgment, but it hasn't been satisfied or collected upon yet. And there's a lot of times where you're in that situation that you have to think about it. The appropriate place to start to think about this, and this is why it jumps into attachments, is before you even file that suit. You don't want to be wasting your time if you don't think this defendant is likely to be able to satisfy the potential judgment. And you need to know where those assets are. You may want to seek attachments and the like while the case is pending, but you don't want to be pursuing a case and then find out far into the process or even at the end that they don't have any assets available to satisfy your potential judgment. I've told you this story before. When I was in Boston, it was years later, but they asked us to try and help them recover on a judgment for the guy had a $750,000 judgment execution against a company that made defective ladders, and the guy broke his back. He was seriously hurt. The judgment was an appropriate amount, but by the time they really started to look at this question about where the assets are, company had gone out of business, because if you make defective ladders, sooner rather than later, you're going to go out of business. Couldn't find what, if any, insurance would have been available at the time. There's no assets left. Poor guy is seriously hurt. They spent years getting the judgment, but they didn't spend the time during the litigation itself to make sure that there were assets left if you were successful in obtaining the judgment to satisfy it.
But you can't get it ahead of time, you said.
You can get an attachment. You can't get to this discovery.
So how do you attach?
You invest. Okay, wait a minute though. You can't get this discovery, but you can investigate public records to see where assets are. We investigate all the time to see if the parties own real estate. If they own real estate, we're likely going to go in for an attachment of some sort. You're not going to find bank account information, but you can get access to other public records. Even your city and town halls show what personal property is assessed, maybe motor vehicles, boats, whatever it is. You might have an investigator look to determine what assets the company may have. Dun & Bradstreet, there are other commercial companies that run valuations and maintain valuations on ongoing businesses as to their approximate worth. If you're looking at suing a fly-by-night company, you better think twice, because A, you're probably not the only one chasing that one down, and B, depending on how much time you have to put into it, by the time you get to the end of the process, there may be nothing. I had represented these investors against this company in New York. It was purely just a BS deal from the very outset. They never should have bought the stock. The stock was sold to them as a false bill of goods. The company had, even though it's it was public company, it had nothing. It was not a Ponzi scheme would be putting it in a good light. And the fact is if we had sued, we would have been another in the long line. We had to try and resolve that early and get the hell out with our money, because when that does come to light, there's no assets there. It's all on paper. It's all imaginary, and it's, they bring Andy in to pay off the earlier investors, and you got to know that at the outset, because litigation isn't always going to be the result that you favor, because it's a lengthy process unless I can find assets so that I know they're going to be there at the end. And so you would actually and should do some significant investigation at the outset to make sure what is available and what likely is, and then what steps during the process can we take to ensure that they're going to be available for me at the end, available to satisfy your judgment. And attachments are what we use during the pendency of the litigation. Do you have another question?
Yeah, can you prevent let's say you're suing a small startup, can you prevent them from going into bankruptcy while the litigation is going? That's something you don't
No, you can't. You could seek injunctive relief potentially against them transferring assets other than in the ordinary course of business, say. But the fact is that sometimes in the ordinary course of business, we go bankrupt,
right,
and seek protection under the bankruptcy laws. So I don't think you can't get that type of order, but we could seek other orders that might try to preserve some more of the status quo during the pendency of the litigation. But the problem is in just what you fashioned. We've got a small startup. They might make it, they might not. There's a lot of money going out. Hopefully there's some more coming in, but it's not a situation where until you obtain a judgment that the court is likely going to be allow you to really dictate how that company operates. So let's talk about attachments, because that is one way during the pendency of the litigation that we try to ensure that there are assets available towards the end of this process. And this was a case in federal court here in Boston. And they used RICO, which, by the way, RICO is one of the federal statutes that you should be aware of, because it originally was seen just as a statute that was sort of going to be used against organized crime and the like. But we plead RICO a lot of times in federal court in our civil complaints. And And it actually is a statute that provides a significant relief and can be used in a variety of settings. And all it takes in order to be guilty of a RICO violation is 2 or more predicate criminal acts. So it's a statute that has a lot of breadth to it, and it's not just something you see in criminal actions. You see a lot of civil cases, as this one is, that allege RICO violations and the like. And they were seeking an attachment over the property that the defendant had that was real estate. Real estate is a public record. We can see the real estate is going to be on the public records in the county in which it exists. You can find out who the assessed owner is generally from the assessor's office in a given town, or you can go to the registry of deeds as well and then track down that title to the real estate. Because real estate attachments don't dispossess the owner of the property, but merely act as security for any potential judgment, real estate attachments are the favored method while a piece of litigation is pending. Now, it will prevent, in all likelihood, the defendant from further mortgaging the property, but it's also there as security for you in the event that you ultimately obtain a judgment. It also protects your place in line from other people that might come subsequent to you. So real estate attachments, we use, and you should think about using them a lot. And for both business and individuals, it's something we look at. And it's a method of obtaining that security down the line. Here, it's a pretty significant piece of real estate that they're seeking to obtain the real estate attachment over. These Curry's motions to modify the attachment. The plaintiff had received a motion for a real estate attachment in the amount of $3 million against property owned by Raymond Curry and Mary Curry collectively. Their properties are located in Clinton, Mass. And both properties are located in Clinton, Mass. And the court authorized $3 million attachment. They were attempting to sell a portion of the property, so that's why this issue is raised sooner rather than later. First of all, with respect to the attachment, if you look at page 20, it says Federal Rule of Civil Procedure 64 talks about the rule with respect to attachments and the like is going to be employed using Rule 4.1 of the Mass Rules of Civil Procedure. And so the question is, what's the standard? So we use Rule 64 for seizing a person or property under the federal rules, and it also makes reference to Massachusetts Rule 4.1 for in order approving attachment. It says the standard is relatively low if you look at it here. The court must find the existence of a reasonable likelihood that the plaintiff will recover judgment in an amount equal to or greater than the amount of the attachment over and above any liability insurance known or reasonably known to be available to the defendant's Mass Rules Civil Procedure 4.1. Okay, so what we're trying to do is obtain security. If there is insurance available to satisfy the judgment, then you're not going to get an attachment, but the good news is you don't need it. So one thing this helps to do is flush out whether there in fact is insurance available to satisfy a judgment and what those insurance limits may be. So and that's a good thing to know, even if we just want to know that we're not wasting our time, but it goes well beyond that because it tells us what the upper limits, at least as the insurance company would see, of their exposure here is, and it may give us room to start a discussion. So seeking an attachment, just seeking an attachment should flush out whether the existence of any insurance that might be available to satisfy it. So from a practical standpoint, that's a really important piece. The other piece is that I really am looking for security of some sort to know I'm not wasting years of my work on this. And so to the extent there isn't insurance, the the attachment will give me that protection. And all I've got to do is, as you see what it says, a reasonable likelihood that the plaintiff will recover judgment over and above whatever insurance is available to satisfy. That's a relatively modest standard in order to succeed. And so that is the standard with respect to the approval of the attachment. If the defendant doesn't want their property attached, but the court still feels there's a reasonable likelihood, then they can post a bond or they can post other security. And if they want to get the attachment released, potentially they can post a bond or some other form of security. But it provides that protection that we're seeking. There's a couple of other things that I want to make reference to on this page 20 that I think are important, and we'll go back a little bit. So that's the standard for attachment. It says here in footnote 2 that the parties didn't file the memorandum in support as required under LR 71A11. However, they say they've got a good defense. Do you know what that is, LR? Because what those are, and you guys need to know, is that within every federal court, there are local rules as to how the court conducts its business. And so it's not just, oftentimes when I'm reading one of the main rules from Civ Pro, I'm reading the federal rules of civil procedure to them. Those govern the procedure in all the courts across the country. Every district has their own local rules as well that you've got to be familiar with if you're practicing there. And that is a local rule here. Local rule might dictate the length of the brief in federal court, the size of the font, but they will also dictate such things as before filing any motion on a discovery dispute, you must confer with each other and put a certificate on your motion that you have in fact conferred, who was present and what the problems were. I just want to make sure that you know that there are local rules in every federal court, because when I got sworn in at federal court, Judge Wolf asked us, how many of your professors told you that there were in fact local rules of this court for the practice before this court? And we raised our hands, but we didn't know, okay? we didn't throw them under the bus, but I want to make sure, because it's the easiest way for courts to deny you whatever you seek, is that you didn't comply with what these local rules are. And so it's not just one set of books when we ultimately practice law and we're in civil litigation or criminal litigation, because the local rules are going to apply to both. And so you want to make sure you get copies of those and understand and follow those as well, because the local rules will dictate. Some of them are more mundane and basic matters. Other rules are more strict requirements that also dictate. They dictate what you must do, but they also, I think, convey to you that the court expects you as lawyers to attempt to try and resolve many disputes before you simply run to them and say, look at this problem. And if you don't do that in good faith, they simply they do not want to hear from you in federal court. Federal court, the local rules are very, very important to how they practice, and they must be followed. And it's an easy way for a clerk to look at something in the paper and say, no, they are out, they didn't do it right. One less hard think problem I had for today. You make everyone's job easier if you don't follow the rules, because it's easier to deny you what you might be entitled to get. So I want you to make sure you guys know that there are these local rules. So we've got this problem on the attachment. They then filed a motion for reconsideration. They placed over $1.25 million in escrow as prejudgment security for the plaintiff. So the plaintiff already has some more protection than they had at the outset. And in going through the case, what they talked about is what was necessary for RICO as well, and how this all came about. Digital Equipment at one point was, like the largest computer company in Mass, and you'd never heard of them now. But what had happened here is, as you see, is the RICO, it says that the court felt that, in fact, there was a sufficient showing under RICO as to what these parties were doing with respect to Digital Equipment's property, and in fact had taken a fair amount of that property such that the court felt $3 million would be appropriate. There was some concern, as you read the case, about how we're getting to $3 million. And if you look at page 25, there seems to be some sketchy whole nature about how the property is valued and everything else. So I mean, again, we don't know quite how they're getting to the number as clearly. But the question is, well, how are we going to protect the security during the pendency of this action? If you look at really the last couple pages of it, the question is more about, well, we can't be certain at this point because attachments happen at a relatively early stage of the process. We're trying to figure out a general valuation for what the plaintiff's damages may or may not be here. They don't have to establish with any certainty at the outset of the case because, again, the attachment hearing happens relatively early in most cases. And so they're going to have to figure out exactly how we get to this number. But go back to your standard under Rule 4. Is there a reasonable likelihood of success that the plaintiff will recover a judgment excuse me, over and above the amount of any insurance available? And there's no showing that there's any insurance available. Plaintiff is not required to post a bond, and the federal cases are no different with respect to the bond. The bond deals more when they were worried about ex-party attachments without notice. But this attachment, the parties were heard on. The defendant had ample opportunity to be present information opposed to it. The Massachusetts attachment statute and rule doesn't have to balance any harms like injunctive relief does. It's simply about a reasonable likelihood of success. And if, in fact, as it says here, that someone is going to be transferring property or encumbering their real estate, then that would even justify an ex-party attachment without notice. The court had no problem at the end of the day, even on an attachment as large as this, finding that it was in fact appropriate to grant the attachment because the standard under 4.1 and 64 is really a relatively low standard. Is there a reasonable likelihood of success that they would obtain a judgment over and above whatever insurance is available to satisfy it? And that's how the plaintiff ends up being able to continue to maintain the real estate on the portion that hasn't been sold, and that the amount that was posted in escrow will remain there while this case proceeds to ultimate resolution. Attachments, the standard is relatively low. It's an important protective device. Once the attachment is granted, there's what's called a writ of attachment, and that writ of attachment then has to, in order to be perfected, to perfect the lien, has to be filed at the Registry of Deeds so that it's filed against the real estate and on notice to anyone who might have interest in doing something with that real estate that they should be careful because there's now additional lien against the property that has to be addressed sooner or later. Questions on that one?
So if I see your client attach $3 million to property and the trial takes 3 years and 3% decrease in property value, am I on the hook for the $90,000 if I get smoked?
Who are you?
Okay, I'm suing your client, right?
You're suing my defendant. Okay, okay, and so you get an attachment for $3 million.
Yeah, right. And so for 3 years, that property's tied up. You can't really sell it unless you
deal with deal with the attachment. You can deal with the attachment by seeking to dissolve it, or usually if you're going to dissolve it, it'd be by posting the bond, or like they did here, agreeing that they would sell it and put the proceeds in escrow. But okay, so you don't do those things.
That's how you would cure it, though. You could sell the property, put it in escrow. And I'm just saying, there's a potential loss on you if I'm wrong and I...
Loss on who? The defendant?
Yes.
Yeah, but if you're wrong, but again, it's the same thing as if the court was wrong in granting the injunction early on. But at least there, you could say we have the bond. Here, the court made a determination that there was a reasonable likelihood of success on the merits. The fact that at the end of the process, the court was wrong, the court approved your request. At the end of the day, they're responsible for whatever harm that the defendant ultimately suffered. You simply made the request to the court based on what you thought was in good faith. The court doesn't find that you are successful at the end of the day. There's no ramifications to you.
Wow. So that property goes down 3%. That's $90,000 on $3 million. Over that time, and I lose. There's no liability back to me for that. Wow.
Well, the court authorized the attachment. The court approved what it was you were seeking. Because frankly, 3%, it could be a lot worse than that.
Yeah, right.
You know, the guy who's going to buy it walks away, it drops dramatically. You know, we decide not to insure it, yada, yada, yada. I mean, you can make it a lot worse if you want, a lot worse. Doesn't make a difference. The fact is the court authorized the attachment. The court's going to be immune from any suit in that regard. So you don't have any liability. That's, frankly, though, why in the injunction setting, we have the bond.
Right,
But the bond is to compensate the enjoined party if the appeals court later determines that the injunction was improvidently granted. That's the language, improvidently granted. What that means is not that it was a close call and we went one way or the other, is that the court was clearly wrong in issuing that injunction. And that's the problem, is that, okay, I shouldn't have got the injunction, but this wasn't a situation where the balance of harms didn't tip in my favor, or there weren't other factors that warranted that. You still may be on the hook, and the bond will satisfy it. But in the attachment setting, the standard is, we don't have a 5-part standard. We really have one: reasonable likelihood of success in the merits. It's one of the injunctive relief, but only the one. And then the only other question is are there any other assets available in the form of insurance that would say you don't need this security? Standard's low on an attachment.
There's no reason not to go for an attachment.
Not if their property is there. There's absolutely not, unless you don't have a reasonable likelihood of success. And that's not a good early determination for the court to make, and to make the other side aware, right? I mean, from a standpoint of negotiating the case, I go into court, I think I make a good presentation, the court denies your attachment on the basis that you don't have a reasonable likelihood of success in the merits. Defendant hears that, defendant's lawyer hears that, and says, what the hell, it's balls to the wall at this point, let's go to trial, get this case done. And you've lost some real negotiating position. That's the problem from that standpoint. But that's the risk. But I wouldn't think you'd be seeking an attachment if you didn't think you had a reasonable likelihood, regardless of what the judge says, because that's the other part of it. It's an early determination. Things change through discovery. Things change over time. The fact that the court didn't see it the way you still feel is appropriate shouldn't change your resolve in the case. It just means that you got to work harder at schooling this judge, because you don't always get the right judge. Judge doesn't always make the right decision, and the judge sometimes isn't always properly educated with respect to the merits of the case until further down the road. You hope that by the time they're sufficiently big about recognizing that they made an early wrong determination and now are prepared to do the right thing. Most judges are. Sometimes it's hard as hell to knock them off an early incorrect determination. But those are bad judges, and there's not likely you're going to be able to do much about those folks. One more to do. Aviation Supply versus RSBI Aerospace. And this is, in fact, the receiver case. And the reason this receiver was appointed is because the defendant failed to pay the judgment. And at some point then, after demand was made, and by the way, I'll explain that just briefly. It says after unsuccessfully demanding payment, they commence this diversity action against them, and then commence post-judgment discovery, which we talked about, by deposing Barbara pursuant to 69. That's the post-judgment discovery that you're allowed to do in order to now try and determine what assets may be available to satisfy the potential judgment. He invoked his privilege against self-incrimination. They moved to compel. We ended up getting some financial statements and the like. We still had not resolved the monetary aspect, and then they moved for this receiver. And there were, on the financial statement, major unreflected asset transfers. I mean, this is the problem, is if someone's going to not pay the judgment, which is an order of the court, they're going to do other things, as we've seen from time to time, like in Pier 4 case and all the rest, which, by the way, I was down there today. There is this huge new condo complex going up on a small portion of Pier 4 that I think it's called 100 Pier 4. God knows how much the Athanas family is still making money out of that site based on that earlier case that we saw where, what is a lousy $750,000 a year. My guess is, and I'll guarantee you, I'll bet a 2-bedroom condo is probably going for that lousy $750,000 a year. So it may have seemed piggish, but judging by the activity I saw down there today on the Pier 4, he's making a lot more money than he thought when he decided to take the gamble on that suit. At any rate, they want a receiver, and they want the receiver appointed in order to satisfy this judgment. It is a drastic remedy. It says here on page, my page is all gone. 315, so is that 316 and 317, I think? Yeah, 316 and 17 under Roman numeral 2. It's governed by federal equitable principles. It's an extraordinary remedy justified in only extreme situations. Court can use language like that, but they appoint them all the time, and especially in money judgment cases. It's not just, clean up Boston Harbor or desegregate various housing authorities and the rest of it. They've tried here to get this case on track and get the defendant to pay what they were supposed to. Instead, the defendant has tried to transfer assets, has done various things. There is no further ability the court really has here to force the defendant's hand, and while it is a drastic and extreme remedy, they're faced, as it says here, with willful non-disclosure, false disclosure, transfers to avoid the judgment. What other remedy is the court left with here in order to try and effectuate its judgment other than the appointment of an extreme remedy in order to satisfy the judgment? Is it done lightly? No, but the court says they're not doing it lightly. The fact is that this is really a matter of last recourse at this point, but the court can do it. And this receiver will have the power and the authority to do everything up to and including liquidating that corporation in order to satisfy the judgment. So this is a good case where you see them try to use the discovery, try to get the information, but when you do get the discovery or some information, you see that there's shenanigans going on. Remember, in the Pier 4 case, we saw that too, is just before the second phase of the trial. Just first, when the complaint was entered, they transferred the property, and then there's always shenanigans with respect to attempting to transfer assets in order to avoid their capture either by attachment or on the post-judgment process as well. That's why you've got to be careful and continuously check your public records to see what in fact is taking place there. Here the court had no other remedy at this point but to appoint the receiver. Is it an extraordinary one? Yes. Does that receiver have the power at this point to liquidate the defendant's assets and satisfy this judgment? The answer is yes, and that's what's likely going to take place. They've left the court with no other alternative. Questions on that?
Questions on receivers?
Yep.
Does that apply only if the defendant is a corporation, or can that apply to other business forms as well?
Well, it's usually, you don't see it in other business forms because partnerships it could be as well. But the problem is you don't have the same structure where there is a legal entity that the court can actually appoint a single person to take over. So we most commonly see it with corporations. I don't really know how many other, I mean, I guess we have seen it with associations, unincorporated associations and the like.
A limited liability?
Yeah, limited, and I think you'd see it there. The problem is, no one, well, it's not just corporations. The problem is what powers is the receiver actually gaining over these other entities? And that's what you need to be sure of as to what the court's authority actually is. But the rule actually reads with respect to receivers is that it doesn't limit it to corporations. It's any defendant that the court would feel is appropriate to be able to allow this person to act on behalf of the defendant. Questions? You understand what the final exam is going to look like? You understand when the final exam is?
Labor Day,
13th? Andy says it's the 13th. Do you all agree? Wednesday the
Do you
13th?
know what time?
Do we know what time?
Maybe 4 o'clock?
I think 6.
I think it's 6. I would usually make it 6 because it's an online class as well, and that way everyone shows up at the same time. And if we make it at 4:30, there'll still be people showing up at 6, so we might as well just make it at 6. But I think it's posted at 6, isn't it? Okay? Good luck.